No.
Oh, they don't have it. Okay.
No, they don't.
But I have the slide myself. Because
Unless if, Lauren, if you are using last year's slides, then I can share the slides with them if it's the same slide as last year.
Zukiswa?
Yes, Lauren?
Yes. Earlier on, the two of us chatted and everything was fine. Can you send me the link? No, not the link that you've emailed me, but another link. Send it on WhatsApp, then I can get onto maybe another platform on another laptop and not on that platform. But in the meantime, I'll start. Look, I'll start with a lecture.
What do you mean another link? We should use, everyone should go to another link. I don't understand.
The link to the meeting, but not the link that says link, because that one takes me directly to my email to which you linked it. Do you understand? I want to get in on another email.
Okay, shall I send it to you via WhatsApp or email?
Okay. Still send it by WhatsApp, it's easier.
Okay, all right.
Okay. I'm so sorry about this.
Okay.
Yeah, okay. I've heard that some of you asked the question, okay, can you hear me now on this platform?
yes, you do.
Much better.
Okay, so I'm now on my laptop, but I'm on another platform.
Yeah, we can hear you, but please try and relax.
Yeah, you can hear I'm stressed because I'm wasting time here. Zukiswa, give me,
yes,
with this one that I'm talking on now, can you give me rights as a presenter here, please? Yeah, this one. It is the one that I'm talking to you on now. I don't know which one it is because I'm apparently now on a lot, but this one is on the laptop.
I have given you rights, sir.
You have. Thank you. Right, here we are. Okay, so I'm going to try and share with you my slides, which I use. And then I'm going to start. Now, for those of you who have read through your manual, you would have seen that it's not a big manual, it's not a lot of pages, but it's basically theory. And what we expect from this is that you know the substantive law, because what I'm going to show you and what I'm going to teach you in this week with you is how to do a matter, to get your matter to be heard in court, and specifically in the High Court. Okay, so we're going to start with the sources of the High Court. Now first let me tell you about myself before we go anywhere. My name is Laureen Abrams. I'm an advocate. I practice. I'm a member of the Johannesburg Bar. Yeah, I've been a member of the bar for 20 odd years, and prior to that, I've done other things. And this course I've been teaching for quite some time now. And this is not. It may appear to you tonight that I don't know what I'm doing with this Teams thing, but believe you me, I've done it a couple of times and I didn't struggle like I'm doing now. So I do apologize for that. Link that I'm sharing.
You are?
Yes. Okay. So there you will see a picture of Lady Justice. Right now how are we going to work? Let me start by saying how I like to present. Whilst I'm busy talking to you and explaining to you, and if you do have a question, you can put up your hand And then I'll try and address the question there and then, because sometimes it loses momentum if I'm going to tell you, okay, at the end of the evening, you can pose questions. Because there is such a huge amount of work that we are going to cover, we are going to go into different parts and we're going to do different kinds of actions and applications. And when at the end of the night, so as we go along, just put up your hand and I will then address your questions there and then, whatever I can address. Okay, so starting, this is the Lady Justice. Now, High Court practice, basically this is if you look at this picture, everything that I'm going to tell you, you will find on this picture. And I usually start with this picture just to show you. Now, you would see, and I would usually ask, but not going to waste time now. You would see there's a lot of symbolism in this picture of Lady Justice. Okay, first of all, you would see the blindfold. Now, the blindfold, it's symbolic of the fact that everyone is equal before the law, or justice is blind, as they say. So justice cannot see. And what does that mean? Justice is blind. It means that despite who you are, that doesn't matter. Justice is blind, and you are going to be judged on the facts. And whatever the facts is, that is what the court is going to take into consideration. Okay? So when you do a matter, any matter for that, High Court or Match Court, when you do a matter, the attorneys and the advocates, the legal practitioners, they are required to place evidence before the court. Right? And there's many ways to place evidence before the court. Now, once the evidence is before the court can only consider that evidence. The court must be blind to anything else. The court must only consider that evidence, and the court must base that case must judge that case or give an order or a judgment based on the evidence before it and nothing else. So justice should be blind, and you only judged on the case, and also you cannot be too important not to be judged equally to somebody else. Which brings me to the next symbolic, which is the scales. Now, the scales represent the equality. Everyone is equal before the law. What that means is that, say, for example, there are two parties in a case. There may be more. But if there are two parties, you take each side of the scale, and the evidence is placed in each side of the scale. And what justice tries to bring is to bring it into equilibrium, to make it equal. And if it weighs heavier on the one side, that means that it must be brought up. So justice will be decided on that, on a balance of probabilities. That is the standard of proof in High Court. In the High Court in civil matters, which we are dealing with. We know in criminal law, it is beyond a reasonable doubt, but in civil, it is on a balance of probabilities. Right, so the next symbolism, the next one is the sword. And what that is symbolic of is that justice will deal with you swiftly. Okay, we know swiftly is a relative term, but you will be dealt with swiftly and without fear or favor. Right. And in the last symbolism that I can see there is that it's on a pedestal. So it's a bit higher. And one of the rules of natural justice is also that no one is above the law. And we in South Africa, we know that all too well. We will charge presidents and everyone if they break the law. So no one is above the law. So that is the symbolism that I usually start with. Is there anyone that want to contribute something there? No one? Right, I'm moving on. I am looking at my slides just to guide me through it on another window. So I don't see your window. So if a hand is up, just say my hand is up also so that I know a hand is up. Because I visit there, but yeah. Okay, this is my favorite. Is your hand up?
My hand is up. Yeah,
oh,
yes.
Okay,
I just want to check if there is a special reason why is it a female instead of a male? Why is it a male
A
Not
female.
Is it a
I don't
female?
know. What do you think? What would you think would be the reason why that's a female? Maybe someone in the class can chip in there. I've heard that question before, and I've heard a lot of different answers. One of the answers was because women show mercy. I don't know if that is true, but that was one of the answers. I'm not saying that is the reason. I think that Lady Justice isn't that the goddess of justice, and that time there was goddesses. I don't know. Does anyone else have a take on that they want to share? Maybe no one. Yeah, it is a female because it was the goddess of justice. That's what I know. I don't know about the mercy. Maybe because in that time females were regarded to show more mercy than males in that time. I'm not saying now. I don't know if that answers your question, Mr. Matibula.
Thanks, Advocate.
Okay. Mr. Matibula was here at 4 o'clock, so he knows I've been here. He saw me because I saw him then. Right, so the practice of yeah, the practice of law. This is my favorite quote, and it says, you will find that physical attributes are of no consequence where the battle is one of intellect. Intellect, voice, personality are all weapons in one's armory, but to none can be ascribed any degree of dominance or even of importance. There is, however, one quality that can overcome any physical failing, and fortunately, it is a quality that is used for the taking. It is the quality of being or becoming conscientious and diligent, and I've boldened that. That is a quote by E. Morris in the book Technique in Litigation. He said that in 1969 already. So what is basically saying is that no matter who you are, what you look like, if you have a good voice, if you have a good personality, all of that is good to have. But that can all be overcome if you work hard. So if you have a case and you make sure that you know all the facts of your case, and it's so easy to know all your facts. You just consult, and you consult properly, and you get the facts, and you check your pleadings, you check what the other side says, and you have their facts. So once you know the facts, you are properly prepared, and then you go and you look at the law that applies to those facts. It's as simple as that. Sometimes it's a lot of work, and you have to sit down and really spend a lot of time to decipher everything. But it's worthwhile in the end. If you do know your case, it's worthwhile in the end. And like I say, if you don't have those other qualities, but you're conscientious, you're hardworking, and you're diligent, then you will be a good legal practitioner. No matter who you are up against, even if you are just starting out and your opponent is a senior counsel, that doesn't mean that he's got the overhand. It depends on your facts. It depends how well you know your facts, and nobody can change the facts. And if you know the law, and if you apply the facts to the law, there you go. So nobody has to stand back for anyone. All of us can do it. All we must put in is the effort. That is the message in that quote, and that is why I like it so much, because it just shows that anybody can do that. Right, so we start with the sources of high court practice. Now, we all know what sources are. Sources are basically that where do we find information as to how to practice law in the High Court. Let me just pause here. You have your High Court practice manuals. Now, everything that I'm going to be saying is in your High Court practice manuals, but it is not in the same sequence. You will think that I am jumping around, but I've taken stuff out, and because I'm trying to tell you a holistic story from the beginning to the end, and how I'm trying to let it fit in, so that at the end of the day you at least see the whole story. It doesn't follow the same sequence as it is in your manual, but whatever I'm telling you is in your manual. And remember the exam, the BBST exam that somebody alluded to earlier, that exam is an open book exam, so you'll be taking in your manual into that exam. I don't know if you've already been told about the rules around that, and if you can make notes and stuff and flag in your High Court practice manual, but it is a good manual. You do get to take in, like somebody said, it's over 3,000 pages. You do get to take in all of those manuals. And what can be difficult is that you don't know that in one of those manuals, the answer to what you are looking for is. Now, in the High Court Practice Manual, I can tell you there are a lot of precedents. You know, a precedent is a similar case where there's things that is drafted, papers that is drafted, or documents and pleadings that are drafted. You are going to be required to draft in your BBST. It consists mainly of drafting. So there's a lot of examples, and if you know there's a similar one in there and you know exactly where to find it, then you can just chop and change and make it fit in with your facts, and there you have your pleading that you must draft. So take note of all the, I'm going to sometimes show you, refer you to where there's an example in it, but read your manual and just take note where there are examples and mark it. So if you get something like that, then you know exactly it is in there, you find it. Here's my example. I don't even have to remember it. I just have to remember where it is. Okay, right. So coming back to the sources. So the Act and the rules, those are the main sources. The Act that is applicable is the Superior Courts Act 10 of 2013. And then we have the Constitution, the 17th Amendment Act of 2012, and the Uniform Rules of the High Court. Right. Now, the Uniform Rules of the High Court is what we are basically going to be working with mostly. The Uniform Rules of the High Court is the rules that is applicable to all the high courts in South Africa. And the uniform rules is what you will be required to know when you do your exam. I do think that you are allowed, or they would give you the rules to take in. I'm not sure I speak under correction if they would give you. There's a hand up. Is it still the same hand that was up earlier on? Sorry. Right. So so as for the rules, you will have to get acquainted with it. I think you would have been sent rules by or a link to where you can find the rules. So just I'm going to refer you to the rules as when we go on. Then the next source is practice directions. Now, practice directions is directions that are issued by judges, presidents of the different divisions of the high courts in South Africa. Now, you will see that it is not the same for each and every division. We know that the uniform rules are the same, but the practice directions is different. If you appear in Cape Town, the practice directions will be different for what is in Johannesburg. The practice directions is just directions issued as to how certain things should be done in that division. I can give you an example. For those of you who is in Gauteng, you would, and you've done a few high court matters, you would know that they use court online and they use case lines, right? So nowhere in South Africa except for Gauteng do we have that. So in Gauteng, there are practice directions, particularly dealing with case lines and how you should upload. Each matter should be uploaded before you get a case, before you get a allocation. All of those things around that, and yeah. Also, what they had in Gauteng and what they still have, some matters are heard virtually, like the way we're sitting here now, virtually. Some matters are heard virtually. So, code of conduct during a virtual hearing. What should you do? What should you be dressed? And all of that. You will find all of that information in the practice directions. And other divisions don't have that. So the practice directions usually deals with, and this specific that I've got here is what is in the Cape Town practice directions. That is the Western Cape High Court. Part A says what is the court terms and the times of sitting of the court. But the terms is uniform because it is promulgated in the Government Gazette. It tells you when there's 4 terms in the year, and each term has about 10 or 9 weeks. That is the terms of sitting, and between that we have periods which we call recess. Okay, times of sitting differs from court to court. The Western Cape, for example, the court starts at 10. In other divisions, the judge president might decide that the court starts at 9:30 or at 9. Yeah, you will usually find that there. Documents and pleadings. What documents and pleadings should look like? Sifunda, sorry. Yes, you have a question.
Yeah, I just wanted to find out, because the practice divisions, they differ from division to division.
Yes.
Yes, what regulates them, and are they reviewable?
You mean the actual practice directives? If the judge president, he from time to time issues practice directives as to how things should be done in his division. So you want to know if he makes a certain directive, he says that from now on you must do X, Y, Z.
Law. Yes.
In law, it's you know, I've never thought about that. It's not in terms of an act. It is just they issue practice directions, and they've always done it where they will say, this is what I want, so that the case can move, the case flow in my division moves smoother. So he's empowered to do that as the judge president of a division. That is why I say each division has their own practice directions.
Yes.
But
yes.
is it you ask if it is reviewable? Now we must look at whether is it an administrative function, or is it a judicial function that is doing? What is it, and what kind of a decision is it to issue a practice directive? Because I have never heard that a direction has been taken on review. You know, the court can condone non-compliance with court rules and with directions if you apply and you can show the court a good reason why you could not meet a requirement set in a directive. But
yeah, perhaps you didn't understand the question. My question was, isn't it that the judge presidents of each court division are the ones who make this practice
yes.
Directions? Yeah. So I wanted to ask if from time to time they review these directions.
Oh, the judge.
Yes, the judge.
Yes, they change it as we go along. They change it
as we go along, and then
yes,
also
it will come out.
Okay,
yeah.
So, yeah. Also, what I wanted to find out from you is, isn't it that it's the judge president's discretion? Now, I wanted to know if perhaps you come to a different view on a particular practice direction to that of the judge president. What's the recourse you have as a legal practitioner, whereas you are conflicted because you believe that it should not be enforced on you or anybody else? So I wanted to find out what's the recourse you have when it comes to that.
I suppose you could, if it's in a specific, if it is a specific example and not general, you're speaking about specific direction that you feel you cannot comply with. That is why I said you can always ask that the court condones your non-compliance, but then you have to show that there's a very good reason as to why you should not comply with the practice direction. And then the judge who's sitting and who's seized with your matter, he will have the jurisdiction to decide whether he allows you, whether he can relax that direction. But all in all, people they comply with directions because they know that the courts are very strict with practice directions.
Thank you so much.
Okay, I don't know if I've sufficiently answered you, but from case to case, if a specific one you couldn't comply with and you have a very good reason, then you can you can ask for condonation. You can bring an application for condonation in terms of the uniform rules. Okay. Right, then documents and pleadings. Documents and pleadings, how it should look like. For example, it's written down in practice directions that all court pleadings and documents must be typed in black or blue ink on one side of the document, and it must be double spaced. Stuff like that you will find there. right? And then motion court and the fast lane. Motion court is usually, you know that you get two kinds of proceedings. You get the action proceedings and you get the motion or the application proceedings. Now, motion and application is the same thing, and it's used interchangeably. So a motion is an application, right? Now, motion court is where there are no witnesses who's going to give oral evidence. Okay? Everything is decided on the papers. So they have, obviously then you get a quicker hearing, and it doesn't take as long as an action, because in an action, we're going to call witnesses and there's going to be a lot more preparation involved in an action. Right, so you will,
Hello?
is there a question?
Yes, ma'am. What are, sorry to take you back, what are instances where the court can condone a particular situation during a court practice, in a court practice situation?
What are, it should just say the first part of your question again.
I'm saying a situation where, just an instance or example where you know what you know, an area according to your experience, the condemnations of the court.
Condonation is dealt with in Rule 27. Now, if you want the court to condone you non-complying with any of the rules and even the directives, then you have to bring an application for the court to condone you not having complied. And in order for you to be successful, you must then convince or persuade the court that you have a very good reason, that your disregard for a rule or the directive is not reckless or unwillingness to follow the rules. Yeah, that's basically it. So in the application, you have to demonstrate to the court that my non-compliance with this rule or directive should be condoned because I have a very good reason for not complying. It was not because I was just ignoring the court rules. I am not reckless. I am not disrespecting the court. It is because of this reason. And if it is a very good reason, the court would give the condemnation, because the court can do that. The court can't condone non-compliance with statute if the statute doesn't enable the court to do so. But with the rules and practice directives, the court can do that because those are actually promulgated, the rules and the directives. It's made so that the court can run smoothly, so that parties knows, opponents knows what is expected of them, when it's expected from them, and so that when matters comes to court, people don't fight over those kind of things, but rather fight over the real facts and the real issues are being adjudicated on. So that is why there are rules.
Thank you. What is the fast lane, please, ma'am? Motion court.
Fast lane,
yes.
Fast lane is urgent applications. How do you bring an urgent application? What is required of you, etc.
Thank you.
That is that you don't wait for you don't go into the queue and you wait till you get the court date, but you get in front of everyone else. Now, in order for you to get in front of everyone else in the queue, there have to be special circumstances. So that is what is doing that. Yes. Then Part D of the practice directives deals with trials and other opposed matters. Part E deals with how appeals are being must be set down, and how you go about it, and also heads of argument. In Part F, criminal matters. Now, this is only an example, just an indication as to practice directives, and this is from the Western Cape practice directive, so it's not the others. If you can have a look, it's usually freely available on the internet. On the attorney sites, you will get a copy of the practice directives, and yeah, you can look through it and you can see, and some of the practice directives, especially the practice manuals of the Johannesburg High Court, the Gauteng Local Division in Johannesburg, that practice directive, practice manual is so good. It contains, at the back of it, it contains a lot of precedents of different kind of applications and what it should look like. So if you want precedents, I know people these days are collecting precedents if they have to draft something. That practice manual have a lot of it at the back of it as to the format and what it should contain and all of that. So download it and look at it. It can only serve you well. Right. So I'm moving on. Yes. Who's that? Hello.
Asking which manual it is, ma'am. Sorry, I didn't get that
Oh,
part.
Johannesburg. The Johannesburg High Court, the Gauteng Local Division, that one.
Advocate, will we also be getting these slides?
Yes, I would make it available to you.
Thank you.
Okay, okay. This slide is not just a, what do I call it? A disclaimer. This is not the school slides, it's my slides, but obviously I'm using it. It's not lead slides, it's my slides. I'm using it. If it contains mistakes, which I will probably also notice, and Floors has changed in the interim and I forgot to change it, don't blame the school and say they give you wrong information. It's my slides. So, okay, the only reason why I make it available, in the past I was reluctant, but because people say they're making the notes anyway, so it will just help them. It's easier for them. It's basically it is so that I don't forget to tell you everything, because I'm a lawyer and we digress when we talk and then we forget where we were. It keeps me on track and it sees that I cover everything. So I can just have it and then I only look at it and talk to you, but I think it's best if I also put it up because it's just pointers. Right, the next source of High Court practice is textbook and electronic sources. That is pretty straightforward. I've mentioned a few there, but we all know that when we want to know something, we can go to textbooks, we can go to the electronic sources, Tutorstat, LexisNexis, and we have Safely, which is also freely available on the internet if we don't subscribe to any of the others. So that is also a source. Then we look at the common law. Now, inherent jurisdiction, do you know what inherent jurisdiction is? Does anyone know what inherent jurisdiction is? Okay, let me just go on and tell you. The inherent jurisdiction.
Inherent jurisdiction, ma'am, it is, you know, the right that the courts have to actually alter their own rules, you know.
Yes, that is one of yes. The inherent jurisdiction is actually
jurisdiction provided by statute.
Yeah, no. That is exactly what it is not. Okay, so the high courts have inherent jurisdiction, right? Magistrates courts do not have inherent jurisdiction because magistrates court get their rights from statutes. That is why you hear the term the magistrates court is a creature of statute, right? So the magistrate court can only do what a statute empowers them to do. Whereas the High Court has inherent jurisdiction. That means even if it is not in a statute, but it is provided that it is not illegal, then the High Court can hear that matter and can give it a judgment or order in that matter. That is the inherent jurisdiction. It is the unwritten power, as it is stated here, without which the court is unable to function with justice and good reasons. And it is enjoyed the court by virtue of its very nature as a superior court, and it's modeled on the English court. But it's basically that the High Court can give you any relief provided it's not illegal. So you can go to the High Court and say, it's not in an act, but I want this relief. This is the case that I've made out. And if the court is satisfied that you've made out a proper case, he can give you that relief. So for those of you who are in practice, and I presume most of you are, you know, if you've looked at High Court pleadings, if you look at the prayers, now for those of you who don't know what prayers are, at the end when you ask, therefore the plaintiff asks for relief in the following terms, and or in a notice of motion, you will ask for relief in the following terms. You will see that one of the prayers is always further and or alternative relief. Now, what that is where the inherent jurisdiction comes in. Because you would ask for certain things which you will be specific, because that is why you're in court. You want the specific relief. That is why you appear in the court. Now, if you don't get that specific relief because the court says, no, you didn't make out a case for that specific relief, but you made out a case, the facts that you have and the evidence that was before the court makes out a case for something else that you have asked for, some other relief. Then in terms of that prayer, further and or alternative relief, the court can do that. He can give you that other relief because you are covered in that prayer. And that is also the inherent jurisdiction of the High Court. Okay, so the Magistrates Court, although I see some people when they draft Magistrates Court's pleading, they also ask for further and or alternative relief. The Magistrates Court can't really give you further and alternative relief because it doesn't have the inherent jurisdiction. Okay. Right. The Constitution, Section 173, has codified the High Court's inherent power. It says the Constitutional Court, the Supreme Court of Appeal, and the High Courts have the inherent power to protect and regulate their own process and to develop the common law, taking into account the interest of justice. Okay. Case law, looking at past case law, that also tells you the inherent jurisdiction of the, sorry, it's also a source of law. So case law is also a source of law. Looking at the updated relevant decisions, and yes, there's a hand. Is that hand still, Aphis, is your hand still up from earlier on? Right. So do you know this principle of stare decisis, as some of you may pronounce it, which is basically that the court, the lower court, is bound by the decisions of the higher court. Okay, and you all know that principle, that is a common law principle, but it's applicable. So the courts, the court in a specific division, the Magistrates Court in a specific division. For example, in the Western Cape High Court makes a decision, then all the on a specific point, then all the Magistrates Court are bound by it. And the Western Cape itself are bound by it, provided that it is not argued in the High Court that it is specific, that it is wrong. And the other is wrong. And the judge says it's wrong. So for that division, all the courts are bound by that decision. But somebody that lives in the Eastern Cape, he is not bound by a decision of the Western Cape High Court. Okay.
Advocate, if you may repeat what you just have said, I missed it. I did not understand it.
Okay. The rule of stare decisis, the precedent rule. It means that the lower courts are bound by a decision of the High Court. Right? Now, in a specific division, all the courts lower than the High Court are bound by that division's on a specific point. But a specific division doesn't bound another division. So if something has been decided on a point of law in the Western Cape, all the Western Cape Magistrates Courts are bound by that, but a court in the Eastern Cape is not bound by that. The Court of Cape will be bound by a decision of the Eastern Cape High Court. Right? And that is why we sometimes find that different divisions have decided differently And then the matter is taken on appeal by someone if we're lucky. And then the appeal court, the Supreme Court of Appeal, when they make a decision on something, then it binds all of the courts. And then obviously the Constitutional Court also binds everyone. For example, do you remember that case with the Marie Johanna Dagga, me rather say Dagga, with the Dagga. The Western Cape first decided that it is not illegal in certain instances, and it was only applicable in the Western Cape. It was not applicable in the whole of South Africa. But once the Constitutional Court made a decision, then it applied to the whole of South Africa. Okay. So, Supreme Court of, is there a hand up? Yes, you may okay. Right. You will see if you look at the Superior Courts Act that there are a lot of, there's about 10, if not more. There are 10 different divisions of the High Courts. Now, I just want to, you have to know this to show, if you are going to draft something, to show out of which court you're going to issue your proceedings, because that will indicate that you know what court has jurisdiction to hear your matter. Okay, so if you look at the courts, you would notice that there are some divisions that have more than one high court. Yes, Mr. Chwene, Sequela.
Yes,
is it Ms. Sequela? Sorry.
Yeah. I just wanted to be sure that I'm clear on what you said previously in terms of law courts being bound by decisions of the High Court. Does it happen sometimes in practice that you find that maybe a High Court like the one in Polokwane, for instance, has not yet adjudicated on a certain matter, but you know for sure that there is case law in the Gauteng division? Can you not rely on that case law?
Yes, you can use it. It has persuasive value. You can use it in order to persuade the court to make a similar decision, but likewise your opponent can argue against it. It's not bounding on but it can persuade them if you can. Yeah, you can certainly use it in your argument, and your opponent can obviously argue against that. And depending on what the judge sitting in Polokwane now believes is the correct one, he will make a decision and give his reasons as to which version he preferred and why. Yeah, you use it as persuasive value in another division. Okay. I don't know if I've answered your question, Sequela.
Yes,
is it Mpako? Yeah.
Yeah, thank you.
Okay. Yeah. So if you look at the list of the courts, you would notice that some divisions have more than one high court.
Prof, sorry
Right.
to interrupt.
Yes.
Yeah. I had my hand raised. I just want
sorry.
to find...
Is it
no, it's fine. Yes, okay. And then I just want to know something. Is the same applicable with the same Supreme Court of Appeal in terms of divisions? Whereas maybe you win that particular appeal at the Supreme Court of Appeal, does it only bind only that high court in that particular division, all the high courts?
It binds everyone because it's higher than the High Court. So okay, once a decision has been made in the Supreme Court, it's applicable then in the whole of South Africa.
Okay, thanks.
Yeah, and the Constitutional Court also. Okay. Right. Getting back to the list of courts, you would notice that there are some high courts, some provinces, divisions that has more than one high court. If you look, for example, at Gauteng, they have two high courts. They have the one in Pretoria and they have the one in Johannesburg. KwaZulu-Natal is the same. It has two high courts. It has the one in Pietermaritzburg and it has one in Durban. And Polokwane, I think, also have two. I'm not sure it's Teoyando, and I don't know where's the other one. That lady can help me, Sequela. See, she would know.
Polokwane.
Polokwane. Yeah,
Yes.
they have two. Yes, and then if you look at the Eastern Cape, you will see they have 4 high courts. Now, usually, a division would have 1. Okay, somebody's making a noise. A division would have 1 provincial seat, and it would have the others. If it have 1 other, that is the local division. Eastern Cape, that is the local divisions. Right? Now, how does that work? So it has 1 provincial seat. For example, in Gauteng, Pretoria is the provincial division, and Johannesburg is the local division. In KwaZulu-Natal, Pietermaritzburg is the provincial division, and Durban is the local division. And in the Eastern Cape, Grahamstown or Makanda is the provincial division, and all the others, the Ciskei, Mthatha, and Port Elizabeth. Not Ciskei, it's Bishu. It's Mthatha, Bishu, and Port Elizabeth. Those 3 are local divisions. Now, how does that work? The provincial division, so they have 1 JP, 1 judge president. And for the other divisions, they usually would have a deputy judge president in that division, but it is still overseen by the judge president or the courts. So he makes the practice direction for that whole division. Now, the provincial division of a specific division has jurisdiction over the whole of the area, right? And the local division only have specific jurisdiction, geographical jurisdiction. It's only a specific area that and it's only geographical jurisdiction. It is not by a matter of the court case is more important. That is why it goes to the provincial division. No, all the judges are judges. Say, for example, the Eastern Cape, all the judges are judges of the Eastern Cape High Court, and they all fall under the JP. But depending on at which local division they are, there's a deputy JP, but they all fall under 1 judge, and they are all judges of the same division. So they are of equal status. It's not that if a judge sits in the local division, he's lower than a judge that sits in the provincial division. They're all equal. They are all judges. It is just as far as geographical jurisdiction is. And the reason why the Eastern Cape has 4 is because of our history. There used to be this states, independent states that had high courts. And when we became South Africa, the high courts remained, but they were just incorporated into the High Court of the Eastern Cape. So that is why they have the Bishu and the Mthatha, because those were high courts then for those independent states back then. And that is the only reason. It's not because they are bigger or more cases happen there, because clearly that is not the case. So, say, for example, something happens in Durban. The litigant then can choose to issue out of Durban High Court, or he can choose to issue out of Pietermaritzburg High Court, right? Because both of that courts will have jurisdiction to hear the matter. But if something happens, for example, in Richards Bay, which is also in KwaZulu-Natal, that person don't have the choice to go to Durban because he's not geographically in the area of Durban. He'll have to go to the provincial division. I don't know if you understand that. So then we say that the provincial division and the local division have concurrent jurisdiction in the local division's area. So they both have the same jurisdiction. The litigant can choose which one in that geographical area, which court is going to issue out of. But anywhere else, the court, the provincial division is the court that has jurisdiction. Right, and it's only geographical. It's not amount of money. It's not because it's the High Court, and it's not important. That's why the provincial division must get it. The judges are all judges. They are all on the same level. It's not that the one judge is better than the other judge because he sits in the provincial division. Right, that is the Constitutional Court. We all know the Constitutional Court. Yeah. Are there any questions? Okay, so this is back to this. Yes. Oh, I didn't see. Yes.
Okay. Yeah, I just want to check in terms of your sources of law. You've mentioned a number of them without any reference to indigenous law, and I'm wondering why that's the case.
Oh. Indigenous law. Yeah. The source of high court practice. I'm not talking about sources of law. I'm talking about source of high court practice. Law to practice in the high court.
All right. No, it's noted.
The question, I don't know. I don't. Yeah. Just tell me why you're asking me why I say that indigenous law is not a source of the high court practice.
Well, I was thinking about it from the perspective of laws that may be applied when one deals with a case at a high court.
No, all the laws obviously applies in the high. All the substantive law applies in the high court. I just said, where do you find out how to follow the high court procedure? That is the sources for that, what I mean. And not sources of law in general, but sources as to where do I find information as to how to bring my case forth in the high court, how the procedural aspect of it.
Okay, no, that's fine.
Okay, thank you. Right. Coming back to our sketch, not our sketch, our picture of Lady Justice, just illustrated here again, and this is in your notes. The principles that underlie the law of procedure in the High Court. First and foremost, we must have an independent and impartial judiciary. And then it says that the judges must consider evidence, motivate the judgment, and the decision is final and binding. So our judiciary must be independent and impartial. The blindfold, justice must be blind, it must be impartial. Obviously, independent, standing alone, making the decision. Consider evidence. Like I told you, legal practitioners place the evidence before the court in a specific matter, and the court can only consider the evidence before it. And if you, for one or other reason, did not place a specific piece of evidence before a court, you can't complain because the court can only consider what is in front of it. And if the court considers the evidence, the court must motivate a judgment. So the court can't just say, I decide X, Y, and Z. The court must give reasons. If the court does not give you reasons, you will have the right to apply for reasons in writing. And then they must comply with that request within 10 days of being so asked. So in their reasons for the judgment, they must say why they have accepted certain evidence and why they have rejected certain evidence. So they must say, I accept this evidence and I believe it because of X, Y, and Z. And I don't believe that evidence because of X, Y, and Z. And the decision is usually final and binding, but it is subject to the litigant's right of appeal or review. Right. Then there is another principle that underlies the law of procedure in the High Court is the equal opportunity, the scales. First of all, the first rule of equal opportunity is that proceedings must in principle be in public. Now, we do know that there are exceptions to that when proceedings are not in public. For those in civil procedures, specifically in civil matters, it would be, if you've heard of it, we're going to do it later on. An Anton Pillar application, it's usually not in open court because of the very nature of an Anton Pillar application. An Anton Pillar application is where you ask that evidence be preserved before you institute proceedings. And usually you wouldn't want that to be in public because you wouldn't want the respondent to know that you're bringing that application. Right? And then you can apply in certain divorce matters. So people apply that it be not in public, that matter is not heard in public. But in principle, all proceedings are, and that means that the public have access to the courts. It's an open court. Right? Then matters, with criminal matters, you do know that when children are involved and in certain sexual matters, sexual offences matters, the members of the public are not allowed in court. Also in domestic violence matters, you are allowed in terms of the domestic violence regulations to bring certain people to support you, but it's not generally open to the public just to go and sit and listen to other people's cases. Right. The second rule is the rule of audi alteram partem, listening to the other side. Now, again, it's still the scales of that picture. Listening to the other sides, there are more than one side. And how do we apply this audi alteram partem in all our proceedings? How is the court convinced that, look, the audi alteram partem was applied and I can go ahead and I can give this judgment? It's the following. The defendant is notified in each and every case. The defendant is notified, or defendant or respondent, if it's an application, notified of the matter, the nature of the case, what is the case about, and he's given an opportunity to come to court to say what his side of the case is and why this is wrong and shouldn't be granted. And how is that done? Well, we use the sheriff of the High Court. The sheriff of the High Court would notify the parties, the defendant or the respondent in proceedings. Each process, every first process must be given by the sheriff of the High Court.
The advocate has disappeared.
Yep.
She's breaking on my side. I don't know if that's happened to everybody or it's my network problem.
It's happening. It's just breaking badly. The network is horrible.
It's breaking for everyone.
Yes.
Okay.
We've got a storm here.
Yeah, my side.
Yeah.
Is that Pretoria?
No, I'm in Joburg, Randburg, but I can hear outside the thunder's coming and it's lightning everywhere. And also I went off for a few minutes.
Yeah, Pretoria is the same. We also have a storm here coming and thunder and lightning. It's quite bad.
Okay. No, here in Pietermaritzburg is very, very nice weather. Thank you, sunny.
Let's hope it's not Friday.
Can anyone else hear her now? I can see the presentation, but I can't hear anything.
I see it also, but I can't hear also.
Can you hear me now?
Yes.
Yes.
Thank you.
Yes.
Thank you.
Thank you.
Yeah. Okay. So, Sifunda, is your hand up from earlier on, or is it a new hand that is up?
No, it's a new hand, Prof.
Yes.
Yeah, Prof, if I may ask, what are the factors actually that may warrant a court granting an applicant perhaps allowing them not to have their matter be presented in an open court. So I'm just curious, what are those factors that you consider?
Well, you have to bring an application, but I mean, I can't tell you offhand what it is. I know that some people to argue the matter of their rights, their personal rights are being infringed. I've seen that, where people say that this shouldn't be in open court because it's personal information and it shouldn't be for everybody to hear. And they bring an apply, but that is not an in principle, everybody must be treated the same. Okay, so somebody's Slappy. It sounds like she's in the rain. Mabatu, we can hear you. It sounds like she's in the rain.
Bring the other man. What man?
Hello?
Please.
Something seems to be happening. I don't have that right. I don't have the right to mute her.
Hey, yes, you can't hear.
I think they are overwhelmed. Storm something they're happening.
Yeah, there's something happening to them. Shame. No, it's not. It's not. We'll see if I can mute her. Hello.
Please bring them up in the bucket. That bucket was supposed to go out.
Can Sakiswa not mute her?
I don't know if Sakiswa is still here. I don't think Sakiswa is still here. Sakiswa is not here anymore. And I can't seem to see her anymore. I'm just trying to see.
Find that you can't hear them.
I'm sure she doesn't even know she's on. Okay, there. I'm muting her now. I muted her. Hey, yes, I got it right. Okay, where were we? I was answering a question. Just can you repeat again? You were asking when? Hello?
Oh no, Prof. I was asking is that when it comes to the court granting perhaps someone the right not to have their matter presented in an open court. What are the factors they consider for that particular applicant who's asking that his or her matter not be presented in an open court? And you answered to say there are quite some factors, but you were not specific in your answer.
Yeah, I can't give you a specific when. It depends. It's the court in this court's discretion. But I mean, saying that it's personal and you don't want to be embarrassed, that is not a good enough reason that I've seen myself. That is not a good enough reason for you not to have your matter in open court. But if it is of a very personal nature and you can, like I say, the rules are there for the court. The court can condone the non-compliance with any of it. So, I mean, even now with COVID, we had where matters was not held in public, where the court said only the legal practitioners and the clients can come into court. So you can see the court can condone and the court can change so that the court runs smoothly. So if you can make out an application as to why you don't want your matter to be not to try, but I mean, I'm going to tell you straight off, for personal matters or because you don't want to be embarrassed and all of that, that is not a good enough reason. Matters where there's children involved, the court might indulge you if they are minor children and their rights, because the High Court is the upper guardian of all minor children and will always do everything to act in the best interest of the minor children. So if there's minor children involved, you could bring an application and say minor children are going to be affected and how they're going to be affected, and then the court can say, look, we're going to have it in closed court. Yeah. like you say, you were correct. I couldn't give you a direct answer because I never really researched. But I can only say what I've seen, and I've seen that it was refused in certain instances where people wanted to not be embarrassed because, yeah, they felt that they were important and everybody's going to hear about this matter. No, it's not like that. We do know that if in criminal matters, for instance, if a person has not been charged, then the name mustn't be published, and that mustn't be made public yet. But once a person has been charged or court, not charged, as pleaded, the name can be made public and you don't have any protection, except if it was a youth, a child. So I don't know if that answers your question, but that's the best go I can. Yes, thanks.
Thank you so much.
Right. Any other questions before we move on to officials of the High Court?
Yes,
okay, so we just, yes, you may proceed.
Remember, let's just retrogress and go to where you said at times you'll find that a province has two divisions. That is your provincial division and the local division.
And local.
Yes. And you went on to say in each case you'll have one judge president. And then you say, let us make an example with Gauteng. Gauteng, you'll have your provincial division, which is based in Pretoria, and the local division, which is based in Johannesburg. But we are told, I'm not sure it's because of my ignorance, but I have this perception that the judge president of the Gauteng, of all these divisions in Gauteng, is Justin Mlambo, who is based. Yes, but he's based in Johannesburg, which is a local division, ma'am.
No, but remember, he's based in Pretoria.
Oh yes. Pardon my ignorance.
Yeah.
Oh yes.
Yeah, because but both Gauteng, both Pretoria and there's a deputy JP in Pretoria who's Ledwaba. And then there's a deputy JP in Johannesburg, that's Roland Sutherland. And they are the DJPs, and they're busy running the matter if you need permission, some permission of the person in charge of the court for certain things, you would write to the head of that court. It would be to the DJP then of that local division. But the JP is still in charge of everyone, and all the judges are judges of the Gauteng division of the High Court, irrespective at which court they sit of the two.
Okay, thank you so much, ma'am.
Okay. Right, so coming back to the officials, we start with judges. So some of you would know what is the qualification of a judge to become a judge? What are the qualifications that you must have? None of you? Did you ever look at that?
You have to be an attorney.
A what? You have to be a?
Yeah. Lawyer first. You have to be a lawyer first. A lawyer.
Yeah, I hear you.
With experience in practice, obviously. Then it's usually a political appointment most of the times.
A political appointment. Okay. So how are judges appointed? We do know that there's there's somebody again on. We do know that there is a JSC, the Judicial Service Commission, who interviews judges and who makes recommendations to the president of the country to appoint judges. Okay, so we do know that. Right, so the judges are, in terms of the Constitution. Oh, before I go there, I just want to ask you a question. How do you explain a judge like Judge Dennis Davis? He would never practice law. So that's your one requirement of they must have practiced as an attorney. or as a lawyer, that falls away because not all judges have practiced as a lawyer. Some of them are from the ranks
We
of
didn't get that.
academics. Hey?
Ma'am, but they sometimes, asked to be in an acting judge position before being nominated for interviews.
No, not sometimes, always. It is more, almost you can say it's an unwritten requirement because you would never, if you looked at judges' interviews in the past, you would see that they never ask, they never appoint judges who don't have any acting experience, because in that interviews, they always refer to judgments that was written by these judges by these candidates who now want to be permanently appointed. So it just goes, it just means that you have to have had acting experience. So to be a judge, you have to have acting experience, but that is not written anyway. The Constitution actually says that to be a judge, you must be a South African citizen, and you must be a fit and proper person, and that is relative, fit and proper person, because sometimes I see the courts have recently, in a few judgments, touched on the issue of what is a fit and proper person, because lawyers, legal practitioners also have to show that they are fit and proper. So if you're going to apply to be admitted as an attorney of the court, in your application, you must also then demonstrate that you are a fit and proper person. Now, what is a fit and proper person? Depends on who's looking, who's reading, and if they're satisfied, okay, no, you're fit and proper. Because sometimes people have criminal records and they think they're not fit and proper. But people with criminal records are sometimes appointed as legal practitioners because they can explain what they've done since then and how they've rehabilitated and all of that. So fit and proper depends on who in fact looks at it and has to decide what is fit and proper. But coming back to it, you must be a fit and proper person. And then it says you must be appropriately qualified and experienced. It doesn't say what qualifications you must have. It doesn't, you're not required in terms of the Constitution to be a judge, to have a legal qualification. It just says appropriately qualified. So appropriately, whatever the JSC wants to say, this is appropriate on the day, that is appropriate. Yes, Akas? Did you say something? Did I interrupt you?
Yes, ma'am. I want to know more about Davis. You said something important.
I just want
to get it.
You said you don't have to yet. You say you don't have to have what?
It doesn't say the requirements. I'll be with you now, Mr. Uyana. Let me just go to Akas. Akas, you say what did you say now? Akas?
You said you don't have to have a specific requirement. I don't know what requirement.
I said the Constitution says that you must just be appropriately qualified and experienced to be a judge.
Oh my God.
It does not say you must have a legal qualification. It just says appropriately.
Okay.
So the JSC who interviews and make a recommendation, they will decide what is appropriately. Now, all the time that they've appointed appropriately is probably a lawyer with legal qualifications, but I mean, appropriately is wide. It can be anything. Yes, then I'm going to answer the next one. Is Iwuwana. You asked about Dennis Davis. You asked about Dennis Davis. What did you ask?
Yeah, you said something important about him that
he didn't practice. Yes, he was an academic. He was a law professor.
Wow, that's good.
And you know, the other one that was also a professor is just Slope.
Yeah.
He was also not a legal practitioner. He was also from the ranks of he was an academic. So yeah.
But is that a title then? If he never practiced, is he having a title? Is that a title?
To be a judge.
Yeah, is that a title?
He was appropriately qualified, and he had appropriate experience. That is that is the requirements to be a judge. Like I say, it doesn't say you have to have a law degree and you have to have practiced law. It doesn't say that. Yeah.
Yeah,
But they
maybe
judge you according to what they can see. This is an academic. He's very good. He does this. He wrote this articles. He does this. Whatever they look at the time, whoever is sitting on the JSC at the moment, and they can find you appropriately qualified and experienced, then they can recommend you. There more hands?
No, mine was just to add, ma'am, that
Okay.
even with Judge President Dustin Mulambo, when he started working as a judge, he did not have an LLB. He actually acquired LLB post after he was appointed judge. I think his previous
I heard that, yeah.
qualification was something else. Yeah.
Yeah, because I remember he said he had to study and he had to study his own judgment, what he said in his own judgment as part of the exam for the
So
LLB.
how then will a person who doesn't have a law degree understand the law? Because
Well,
we're talking
they
about a
hadn't
judge here.
appointed yet, but whoever wrote the constitution wrote that in at the time, because maybe at the time there were people that is not qualified in law, but otherwise qualified, maybe political science or something like that, that would have made good judges. I don't know. That is just how it is. The constitution was written like that. They didn't say you're required. Whereas with attorneys, it says you must have an LLB degree. With them, it doesn't say specifically what degree they must have. It's just appropriately qualified and experienced. And then it doesn't even say you must have a degree if you read further. Yes, Tobak Khale?
Yes, madam. I would like some clarity regarding the issue of the appointment of judges, whether the Judicial Service Commission plays any role in relation to the acting judges, or whether it only plays a role in the appointment of permanent judges.
No, they don't play a role in the appointment of acting judges. That is the judge president appoints acting judges. The person in charge of the division appoints acting judges. That you don't go for an interview to the JSC. They're not involved in the appointment of acting judges because it's an acting judge. Usually, the judge president would invite people to come and act. Yeah. Or you'd make yourself available and see if they invite you to come and act. And usually it is people, the magistrates who also don't practice law, but they sit as magistrates. They also, lots of magistrates has been appointed as judges in recent years. Magistrates are invited, attorneys are invited, of any seniority, advocates are invited, and academics are invited to act as judges. And these people make themselves available. They are called and then they ask anybody want to make themselves available. And then out of that, the judge president may say, okay, you can come and act, or are you available to act? But the JSC does not have any involvement there. It's only in the appointment of permanent judges that the JSC is involved in. Yeah, there's a few other hands. Can you just, are there any more questions on this issue?
Yes.
Okay, go. Mulema.
Find out. No, mine is just a comment, ma'am.
Okay.
Mine is just a comment to say even the people who interviews these charges are not legal people. They have no legal experience, most of them.
Oh, the JSC consists of 23 people, and in terms of the constitution, it tells you where these people come from. It's politicians, so many politicians,
yes,
so many lawyers, so many advocates, so many academics, and all the judge presidents. So it is, yeah, there's 23 of them.
Julius Malema is there.
Mulema, it's not Malema, it's Mulema. Yes, Yugan.
In principle,
isn't there a contradiction?
In principle,
Candidate attorneys, we got to write board exams to practice, but here you get a judge that only if he's found to be fit and proper, he can be appointed.
Yeah, and appropriately qualified and experienced. And then they put you through this, that they look at judgments that you've written, that they look at whether you know the law. They ask you questions. I mean, some of you must have watched, they ask like very simple questions to these people who are candidates. I hear what you're saying, that the requirements to be an attorney seems to be harsher than the requirements to be a judge. Okay.
So,
Yes.
assessor is part of the court officials.
The what?
Assessors.
Assessors.
And the
You know what? I don't know what happened to the appointment of assessors. They're not a court official. Assessor is just a lay person. A lay person meaning that the person does not have to be legally qualified. Now, I say that subject to the qualification, that I know in my experience that usually they take people with some legal background to be assessors, but you're supposed to just be a lay person because you're just supposed to look at the facts and not the law. So you would assist the judge to look at the facts of a matter. And it's only in criminal cases, in certain criminal cases, where you can ask for an assessor. But I know that in Cape Town, I was told in Cape Town, they don't use assessors for some or other reason anymore. I'm not sure what the position is in Gauteng with regards to assessors and elsewhere also. I don't know. But assessors, you know the jury system that we had where you are judged by your peers. So assessors is your peers. But who they use sometimes academics, they use old retired magistrates. And also what I've noticed is they would usually use it with people who have been appointed as judges and is maybe new and did not have a lot of people when they practice, they don't do criminal law. So they don't have such a lot of experience in criminal law. So to put them in a matter with assessors who heard a lot of criminal matters in their match court can be a transfer of skills also. I mean, this is just my observation. It's not written anywhere. This is what I saw. But yeah, assessors is not an official of the court. It's a lay person.
Okay, thank you.
There's more hands.
Advocate. Yes,
Yes.
I just want to find out if a judge is an acting judge, so that, I mean, that's a senior advocate, still a member of a chamber. Do they resign or do they hold? What's happening? Like, do they preside over the case while they are still a member of the chamber?
Well, they're still a member of the bar. You don't resign.
Yes.
You don't resign from the bar to be an acting judge. You still have your practice. It's just that you do acting for however, it can be a week, it can be 2 weeks, it can be a month, it can be longer. Just to let you in on something, it's not something great, but I've also acted as a judge in the Johannesburg local division. And that was part of my pro bono service. Remember, we are all required to do pro bono service. So I would give a week of my time to help out with opposed motions. And a lot of us do that. So you still look advocate, you still have your practice, but for that time, you sit as an acting judge. So it's not, and usually they would require you to have some experience as an advocate before they invite you, before they allow you to do it as part of your pro bono service. Yeah. Tabi Singh?
Hi,
Thank
ma'am.
you.
You please kindly proceed. I think we covered a lot on this topic. We already started the class late, and kindly can we proceed?
Okay. So you want the conversation about judges closed? Does everybody agree with it?
Yes, please.
Okay. The other people's hands are up. Zanele, Ntabi, that's Ntabi saying I spoke to you. Okay, we've got a request that we're wasting time talking about judges. Let's go on. The Registrar of the High Court is the next official. That is the custodian of the files of the High Court. When you have a process issued, now I speak about process. What I'm actually meaning, there's two kinds of proceedings. There's the action procedure where you use a summons, and then there's the application procedure when you use the notice of motion. Must I mute somebody again? Now, when you're going to issue it, that is when you are getting a case number. And when they open a court file, it's Shirley. Shirley, we can hear you. Okay. Right. When they open a court file, that is what gets done, what the registrar does. And then the registrar has other duties. I will point it out as we get to those parts of in the matter. But the registrar is the custodian of all the court files. If files get missing, you have to open a duplicate file. The registrar has a say in that. The registrar also has a say in allocating matters to court, to the court roll. So basically in control of the court roll. They meet with the judge president and they sit and they say, okay, how many matters can we put on the roll? We have so many judges, we can put so many matters on the roll, make it 5 default judgment, 5 summary judgments, or whatever. And then the registrar controls it and gives out dates to litigants. Right, that is the second official. The sheriff is the next one. I've already told you what the sheriff's role is. The audi alteram partem principle, that every person is entitled to be notified of proceedings against them. Now, how does the court ascertain that this is being done? Before the court grants default judgment, if a person applies for default judgment, then usually the defendant is not in court. Or if it's an unopposed motion, then the respondent is not in court. Now the court must make an order or a judgment against somebody who's not present. How does the court satisfy himself that the audi alteram partem principle has been applied? The court looks at the return of service. This is the document that the sheriff completes after he served the process. Now, in all matters, the first process must always be served by the sheriff. The other documents and pleadings that are exchanged after that can be served by your messenger, or arrangements, you can serve it electronically. But the first process must always be served by the sheriff. So, and he must complete a return of service. So if it's a matter where the defendant is not in court, is absent in court, the judge will look at the court file, and if the return of service is there and the return of that the defendant has been notified, he knows about the proceedings, and the defendant is not opposing it or defending it, then the court will grant the judgment, because the court will be satisfied that the other side is heard, and he's heard in his silence by condoning. He's saying, okay, I agree, you can take the judgment. That is the role of the sheriff. Now, the taxing master is the person who is going to tax your bills. Now, the general rule is that the successful litigant is entitled to his or her costs. Right? What that means is that when you are successful, you get your costs. Right? Now, there are exceptions to that. It's not a hard and fast rule. If you are successful, but you didn't play the game according to the rules, you broke the rules, you weren't cooperative and all of that, and your opponent gets up and he convinces the court that you're not entitled, should not get your cost because this and that. Obviously, you can answer to that and say, no, but that is wrong, or that is not correct. But the court can then say, no, you are not entitled to your costs. Okay. Now, when we say entitled, the successful litigant always gets the costs. Once you are successful in your application or in your action, you must now collect the costs from your opponent. The cost is not the cost that your client and you agreed to when your client came to see you. Remember, the client comes to see you, you agree on your rates, what you're going to charge. For example, you say my rate is 1,000 Rand an hour, and this is my estimation. If the matter is unopposed, how much it will cost and whatever. So you've agreed to a certain rate. The cost that you claim back if your client is successful is not that cost. It's not that 1,000 Rand per hour. The cost is set out in Rule 70 of the Uniform Rules. and it is much less than that. And if your opponent is not, once you are successful and you say now you must pay the cost, and your opponent is not satisfied with the costs, he can have the bill taxed. The taxing master will then decide what is reasonable charges for the work done. So, and reasonable not in the tariff, because the tariffs are prescribed, but reasonable in the fact that you say, maybe you've read an email, it consists of one paragraph, but it took you an hour to read that, and you're charging for an hour. So the taxing master will look at that, it's broken down then each and every item, and the taxing master will say what is reasonable and what is not, what will not be allowed. And after the bill has been taxed, then that is the cost that you must pay to the successful litigant. Okay. Right. If there's any hands, I can't see it, so you have to tell me, eh? Then we have another official, the family advocate. Now, the family advocate is the person, the advocate who is appointed by the Department of Justice. It's obviously an advocate, admitted by court as an advocate. And this person has a lot of other people also working at the office of the family advocate. It's an office. Social workers as well as other advocates also. Their role is that in all matters where there are minor children involved, then they must be known, especially in divorces where there's the contact and the care of minor children that has to be adjudicated on. That pleadings must also be served on the office of the family advocate, who will look at it and will look at whether the best interest of the child is served by whatever arrangement or agreement is entered into, or if the parties are fighting over who's going to have primary care of the children and what the contact is. If there's anything like that, the family advocate will then do an investigation and make a recommendation to court what he or she thinks is then in the best interest of the child with regards to that. Then there is the, oh, there's a hand. Zanele, your hand is up. I'm just checking to see if there's hands. Zanele?
It was up a long time ago.
Sorry, Zanele. And then there's another hand, which I can't see whose it is. Okay, there's now no questions. I can move on. The interpreter, now in civil matters, if you have a witness who's going to give evidence in a language that the court may not understand, or that other parties may not understand, that it is incumbent on you as the legal practitioner to see to it that there is an interpreter there who's going to interpret. So say, for example, you have a Nigerian witness and he speaks Igbo, then you must see to it that there is an Igbo interpreter who can interpret to the court in English. Okay, and it is for your client's account. The court don't provide interpreters in civil matters as of right. You have to see to it yourself. Interpreters are also admitted in court as an interpreter, and they basically interpret what is being said. They don't translate word for word. They would interpret the evidence to the court or to whoever it needs to be interpreted to. Right. The court orderly in the High Court, the court orderly is sometimes also loosely referred to as ushers. They are the officials who would, in court, if sometimes legal practitioners want to hand up documents and they say, may I hand up this document to the court orderly will come and get it from you. It's usually also the person who would say stand in court or silence in court, or would give water. I don't know if they give water anymore, but he used to like fill the water jugs of the lawyers, and he would usually bring the judges' books to court before the judges come to court. That is the role of the court orderly. In the High Court, they also wear a black gown, the same gowns that legal practitioners wear. They wear that, and they also wear black and white clothing. So it's sometimes you think it's a lawyer and then it's the court orderly, but yeah, that's their role. And then the judges clerk, just like the Constitutional Court has judges, the High Courts also have judges that does their research. So if a judge wants research on the latest law on a certain aspect of the law, the judges clerk will do that. It's usually people appointed as judges clerk that are LLB graduates or maybe in the final year. And yeah, that's their work. The court stenographer. Now, our courts are courts of record. Everything that is said in court is recorded, and it has to be recorded. If for some or other reason it is not electronically recorded, the judge or the presiding officer makes notes, and they must, sometimes if it's necessary to have a record, they must reconstruct the record from that notes. But everything is recorded, and it's usually not typed anymore, but it is recorded onto CDs. They've got a machine in court, and then everything is onto the CD, and a record to be transcribed because maybe you're going to appeal, then and then you need the record. You have to then have the record transcribed, make an application, send it to the stenographers. They will then send the CD to the firm who has the right to type it, and that would be the officially transcribed record, and the only one that the courts will accept as the true record of what was said in court. Okay, and obviously it comes at a cost. It's very expensive to have a record transcribed. They charge per page, and it's over 30 Rand a page when I last looked. So if a court, if a matter was in a couple of weeks, and the record is thousands of pages, it can be a lot of money to have a record transcribed. But yeah, our courts are courts of record, so everything that is said in court is recorded. And now with in Gauteng, especially with the COVID, and even now when they had virtual courts, it is recorded on this Teams. Microsoft Teams is the app they use. It is recorded on there also. I don't know how they work with a transcription of it. I suppose somebody would also send that, and they would store that. Right. Attorneys and advocates. Now, this is where we come in. It's legal practitioners. Now, we are all legal practitioners. There's a hand that is up, and I can't see whose hand it is. Every time I come here, I don't know if it's an old hand. It's Godfrey Meneses. Your hand is up. Anyways, so attorneys and advocates.
I was answered advocate. You know, I raised my hand when we were still discussing about
judges.
You know, yeah, judges. But I'm answered because you said that I was under the impression that they were not doing law. You know, but then you did clarify that there were professors from universities in the faculty of law and so on.
Yeah.
I'm answered. Thank you very much.
Oh, okay. Okay. Yes. Okay. Advocates and attorneys. Now, in terms of the Legal Practice Act, you will see that you have to have an LLB degree. Now, in the past, the Legal Practice Act came into operation 1 November 2018. Now, before that, you had the Admissions of Attorneys Act and the Admissions of Advocates Act, and they were regulated by two different acts. Now everyone is regulated by one act, and we are all called legal practitioners. Okay. Now, the difference between the two traditionally and still between the two professions, attorneys are not a referral profession, whereas advocates is a referral profession. What do I mean when I say that? Referral means that traditionally and to a certain extent still today, advocates cannot take work directly from members of the public. An advocate can only take work if the matter has been referred to the advocate by an attorney. Okay. So that is the traditional, and that it still exists, but in the new Legal Practice Act, they have made provisions for an advocate to practice as a legal practitioner, as an advocate with a Fidelity Fund certificate. So you get three kinds. You get the attorney, you get the referral advocate, and then you get the trust. They call them trust account advocates, because advocates have trust accounts. Now you may wonder why this is like that. Now traditionally, in terms of the Admissions of Advocates Act, advocates were not required to have a trust account. So they're not required to have a Fidelity Fund certificate. Now we know attorneys have to have those in order for them to practice. And the reason for that is that advocates, because they do not have Fidelity Fund certificates, they do not have trust accounts, they cannot take money directly from members of the public, because the members of the public's money is not protected. Once the advocate has it, there's no insurance, it's not protected because they weren't required. Attorneys, on the other hand, if they take money from the public, it must go into the trust account. And if something should happen to that money, the members of the public would have recourse to the Fidelity Fund. And that is the main reason, because advocates were not required to have trust accounts. They couldn't take money directly from the public. And because they can't take money directly from the public can't come and consult them directly. So the money to an advocate must first go through an attorney. With a trust account advocate, an advocate admitted as an advocate can apply to the Legal Practice Council to be able to have a trust account and operate as an advocate with a trust account. There's then certain requirements, extra requirements, in lieu of already the requirements that he has to have as an advocate, and that's extra requirement is that he has to do the subject of accountancy. Advocates traditionally did not do accountancy, and also he must have a legal practice, must do a course in legal practice management. Yeah, so those advocates can then practice the same as attorneys who have, but they still can't be, in terms of the law, they still can't be conveyancers or notaries. They can't be conveyancers or notaries, but they can practice and take instructions directly from members of the public. Members of the public can approach them directly. Right. In the past, the traditional bars, like that falls under the umbrella of the General Bar Council of South Africa, the traditional bars like the Cape Bar, the Johannesburg Bar, the Pretoria Bar, all of those bars that falls under that, they never allow, they still don't allow up until today, their members to be trust account advocates. So if you're a trust account member, advocate, then you can't be a member of the bar, the traditional bars. There are other bars that has came about since the new Legal Practice Act. We all know, we've heard Papasa, we've heard the South African bars, and there's always been independent bars. In the past, that was where there was bars that wasn't part of the traditional bars, and they stood on their own. Although they stood on their own, traditionally they were still required to only take work that is referred to them in terms of the Admissions of Advocates Act. And remember, in the past, before 2018, 1 November 2018, if you were an advocate, you did not need to have done anything in addition to having your LLB. If you had an LLB, you could be admitted as an advocate. Okay. If you wanted to be a member of the traditional bars, then you had to do pupillage, but you didn't have to do pupillage to be an advocate, only to be a member of the bars. So there was those advocates who didn't become members of the traditional bars, and they just practiced law. Attorneys, the story didn't change much for the attorneys. Their requirements to be an attorney is still the same as it was before. They have to do articles, they have to write the board exam. Yeah. do articles and write the board exam before they can be admitted as attorneys. And also obviously have the same qualifications that an advocate has, the LLB. In the past, they could also have a B Proc. I'm sure still they can have a B Proc, but they don't offer B Procs anymore. So yeah, that is the basic difference between attorneys and advocates. Do I have any questions on that? Because I usually have some questions on that and I would like to answer just so that you know where we are. No questions?
Advocate.
Oh, yeah.
Advocate.
Who's this? Is it Godfrey?
I just want to ask. Hello, Advocate.
I can hear you.
Yes, I just want to ask, what is the difference between a bar and a sidebar advocate? And
Okay.
in terms of being admitted to the title, what are the requirements?
Okay, the bar is what they refer to as advocates, because I don't know if you've been in court, in the High Court specifically. You would see, and this is very logical, it's only, you would see that where the advocate stands when they address the court, they call that I'm standing at the bar, because there would have been a bar behind which they will be seated. And this we all get from English law. There would be a bar from which they are seated. And they would then, if they say, can I mention it from the bar? Or can I say from the bar at where they stand? So people usually, so they call people who practice in the High Court and who could stand there, because remember, a long time ago, attorneys did not have right of appearance in the High Court. They always, if there was work in the High Court, they had to brief an advocate to do that work. Since 1995 only, attorneys could apply to appear in the High Court themselves, where they don't in all cases have to brief an advocate. So that is why they call that the bar, and that is why they said members who practiced at the bar was those that stood there. And by the side, the instructing attorneys would be, and that is why they call that the sidebar. And that is where it comes from. It doesn't have any other intelligent reason. It's only, yeah, descriptive of where they were and in the High Courts back then.
Advocate. And then what about the sidebar? Sidebar.
That is the side. By the side, the attorneys would usually, the instructing attorneys would usually be by the side.
Oh,
and would give
okay.
instructions. It's just where they, yeah, traditionally that is why the name come from. Sidebar is attorneys, the bar is advocates.
Oh,
yeah.
Okay.
That's
because
where
I
it
heard
comes
someone saying that if you've got just an LLB, you can be an advocate and practice. I'm not sure.
Yeah, that was the situation before 1 November 2018. That was the situation before then. But then you're not a member of a traditional bar, but you could practice as an advocate. Yes, the traditional bar didn't take people who didn't do pupillage and passed pupillage to be their members. But you could be an advocate and you could have a bar somewhere and you could practice. Yes. Still referral, still being referred to, work referred to by attorneys, but you could practice. Yeah, anything else?
Thank you, Amasat.
Okay.
Advocate, can we have a 15 minutes break?
Okay, let me just ask, yeah, people need to, and I know it's fast also. I don't know if people had the time to break their fast. I'm sorry, I didn't think of that earlier on. Let's take I'm not going to ask, let's take a 15-minute break. No, not 15. Let's take a 10-minute break, a comfort break. Let's do quickly what we have to do and come back at,
Thank you.
It's about 5:02. Yeah, it's now 4:02. Yeah, let's take a 10-minute break. Okay.
Thank you.
Godfrey, your hand is up.
Wow.
Are we all back?
Are we all back?
Yes, we are here.
Okay,
Some of us are here.
let's continue. The next party is the official, is the Master of the High Court. Now, the Master of the High Court, you must know in all matters where there's a deceased estate that is maybe the subject matter of a dispute in court. So if the case revolves around a deceased estate or an insolvent estate, or even the estate of a minor child, then you have to serve papers of those proceedings also on the Master of the High Court, because the Master of the High Court needs to know what is happening. Especially if since it is registered at his office. So if there's going to be any court order that's going to make a difference to what is on file by him, he should also know so that he can also get that file. I see Sequoia, your hand is up.
Yes. I just wanted to find out, with the family advocate, you had mentioned that when there are minor children involved, that we notify the family advocate. Does this mean like issuing summons that you would also include them to serve at the family advocate's office? Should they be minor children?
You won't name the family advocate as a party in the proceedings, but you would also go and serve a copy of the papers of the proceedings. You would serve it at the office of the family advocate, because the court during divorce proceedings, or in contact and care cases, the court will ask, has the family advocate seen this? And the family advocate would usually endorse it, that is, they stamp it and sign that they are okay, that whatever has been decided is in the best interest, or if it's not, they can notify the court that they're going to do an investigation and then submit a report to the court. So you would serve on the office of the family advocate. Yes, the court requires that.
Okay. At what stage would this be done? Just directly after issuing summons?
Yes, after issuing summons. After issuing summons, you would also go and serve it on the office of the family advocate. Remember, some divorces go through unopposed, so you wouldn't wait. Look, if there's opposing papers that is also filed, and if the parties fight, then that will also then be served on the office of the family advocate. If it's an opposed matter, yeah. It immediately after summons. You also go and yeah. Right. So I think I did the Masters of the High Court. Then the next, the National Director of Public Prosecution. We all know the National Director of Public Prosecution is responsible for prosecution of criminal matters, And in the High Court, the state prosecutors, we refer to them, they are called state advocates because they are also admitted advocates. You do know now that unlike before 1 November 2018, now advocates are also required to take an examination, to write board exams. The Legal Practice Council, in terms of the Act, the Legal Practice Council also requires that advocates do pupillage and does take board exams, not pupillage by the traditional bars, but pupillage somewhere, and that they also write the board exam before they can be admitted as advocates. So the state advocates, they are also admitted advocates, and yeah, and they are the prosecutors, but prosecuting in the High Court. Then the Registrar of Deeds should be known in all matters where immovable property is the subject of dispute. You have to also know the Registrar of Deed, and sometimes people would also cite the Registrar of Deeds as a party just to make sure that the processes are served on the Register of Deeds, but they would say in describing the party that it's only in the capacity as the Registrar of Deeds to notify them of the proceedings, and they're not seeking any relief against the Registrar of Deeds or any cost order from the Registrar of Deeds, but they're only citing them so that because the papers are also being served on them. Yeah. Are there any questions on officials of the court? Then we move on. I just want to make sure there's no questions. Right.
Hello.
Yes, you may proceed.
Hello.
Yeah, I can hear you.
Yeah, I want to find out from yourself if advocates are expected to be experts in all areas and fields of law. For an example, when you say they can only, or in the past they used only to work on referrals, except for now, because the law allows for them to perhaps get clients directly from public. But in terms of referral, they can refer any case, for an example, a road accident fund case, a divorce matter, or any case in any aspect of law. Advocates, they are expected to know how to handle and deal with those cases. That's my question.
Okay, if I understand, you want to know if advocates know everything. Basically, that's what you're saying. They are experts in, not in all fields, but some advocates do have general practices, and when they get a matter, they will deal with that matter and probably prepare as best as they can in the matter. But they're not required to be a specialist in each and every field of the law. It's just that they must, because of the right to access to the law, they must know that they cannot refuse to do a matter unless maybe they feel that they're going to do injustice to a client. Then they can refuse. That is the rules of advocate. Yes. And just correction, I didn't say advocates can now also do work directly. What I'm saying is that if they choose to, they have to apply to do the work directly. It's not as a matter of fact, because firstly, all advocates are referral advocates. And if a specific advocate wants to get work from the public, he must apply for a trust, for a Fidelity Fund certificate and to be a trust account advocate, and he applies to the Legal Practice Council. But then the traditional bars don't want that kind of advocate to be part of that bar. He can be to another bar maybe that allows for trust account advocates. So it's not that advocates can now also take work. It's not generally. It's only if they have the necessary requirements, because you have to meet certain requirements before you can have a trust account. Okay.
Okay, thanks, sir.
Okay, sure. Right. Anything else?
Yeah, my hand is up.
Sure, you can go ahead.
Yeah, I just want to check why is it that traditional bars do not prefer trust account advocates?
Because they decided that they were going to remain as they traditionally were, referral profession. They made that decision. So, yeah, they don't want the advocates to receive work directly from members of the public. They want it to remain a referral profession. I don't know if you're satisfied with that answer, but that is the answer. But there are other bars that would allow. So there are many other bars, and it's not only these days, it's not only the traditional bars that is recognized. In the past, it used to be only the traditional bars that got the work from the big companies, that got the work from the state, that got to work from parastatals like the Road Accident Fund and that. But now people in other bars are also recognized in terms of the Legal Practice Act, and everybody, the work is shared, and people also acknowledge the other bars. So it's not only that, but traditionally, and some people still follow tradition. Traditionally, people used to just brief members who were people who were members of one of those bars, because of the the fact that they know that these people were trained and had to pass an exam before they could be a member of that bar. Yeah. I don't know if that answers your question, but that is the reason. Yes, there's some more hands. Obaking. Sibanda.
Yes, advocate. I just wanted to find out that if you are a trust account advocate, can you still take briefs from attorneys? So
Yes.
can you work both ways?
Yes, you can. You can have the best of both, but it's just that, yeah, you can. You can still be briefed by. I have seen matters in the High Court where some attorneys brief other attorneys, because remember, some attorneys have right of appearance in the High Court. That is also something that you write to the registrar after you've been in practice as an attorney for 3 years. You can apply for right of appearance in the High Court. So attorneys who have right of appearance in the High Court, I've seen, especially with divorces, there's attorneys that does a lot of divorces. So other attorneys give their divorce matters to that attorney to do for them in court. So I've seen attorneys instructing other attorneys to do work. There's nothing wrong with that. Saying you do this matter for me. There's nothing wrong with that. Yeah.
That out, isn't it correspondent work? Is it allowed to brief another attorney as an attorney?
I don't know if they per se say brief. They would say loosely. They would say I briefed as attorney, but I mean I don't know it's brief in the sense of briefing, but giving the work to somebody, giving my client over to take over that matter.
No, I understand.
Yeah, yeah. I don't look. I speak under correction. I don't know how they work out the financial aspects. Does the client pay the first attorney or does he pay the second? I don't know how that. But I've seen attorneys give their work to other attorneys to do for them in the High Court, and not brief counsel per se, but brief one of their own. I've seen that. I just don't know how the financials work. Yeah.
All right, thanks.
Tobakhale. Okay, your hand was up, but
ma'am,
it's not. Yes.
Yes, I just wanted to ask something regarding the state advocate. In the webinar that I attended sometime last year, it was an NPA webinar. And then the presenter there made mentions of the fact that you can become a state advocate through their internal processes and without having gone through the whole pupillage thing and having been admitted as an advocate, but through their own internal processes, you can become a state advocate. So I don't know whether it was correct or maybe I misheard her or something.
I don't know how they can bypass the Legal Practice Act, because in terms of the Legal Practice Act, to be admitted as an advocate, you have to pass the exam, the board exam that is set for advocates, that is set by the Legal Practice Council. So I don't know how you can bypass that. I do know that the state advocates have their own internal training that they give to people who are state advocates, obviously, because that is a specific. But in order for you to be admitted as a state, to get appointed as a state advocate, you must be an advocate first. And how do you become an advocate? You get admitted by court. And what are the requirements to be admitted? The Legal Practice Act says that you must pass the exam.
Okay, so because I thought maybe it would be possible if you were to be appointed through their aspirant prosecutors program and then gain some experience and go through their own internal process, if that was maybe possible.
I don't know if you can just be. I know in the past it worked like that, but you still had to be advocate. You still had to be admitted as an advocate by court. The National Prosecuting Authority can't admit you as an advocate. So you must still, and you must meet the requirements to be admitted as an advocate. Yeah. Yes, there's more hands now. No, to see who's where. Yes.
Yes. Good evening. I just want to find out. I heard one of the guys saying that her principal, I mean his principal he's an advocate, but now he's practicing as an attorney. Possible that you register to the bar and then again you go back and become an attorney and then communicating directly with the client. Is that true?
You can change between the two, provided that you've met the requirements of both. So if you now do your articles and you pass your board exam and you admitted as an attorney, you practice as an attorney for a year, and then you decide no, you rather want to be an advocate, then you meet the requirements, you pass that exam to be an advocate, and you pass that, so you now have the qualification in both. So you can interchange between the two, but you have to bring a court application. You can't be both at the same time. But if you want to be one or the other, you must meet the requirements. So if you were an admitted attorney once, you can practice again as an admitted attorney. Then you remove yourself in court from the role of advocates and get admitted on the role of attorneys, or vice versa. But you can't be both at the same time. But you can change around. But you must meet the requirements of both. Obviously, if you have been appointed, if you met the requirements prior to 1 November, then you don't have to now go and do all the tests again. Then that laws that apply then still applies to you. Okay, so those people who didn't write the board exam and was admitted as advocates, they don't have to now first go and do the board exam because they were already admitted. There's a court order that says they were admitted, so they can change between the two. For now, you'll have to do the exams in both and be admitted as both, but then you can change between the two. Yes, you could.
Okay, thank you.
Advocate, kindly move to ethics, please.
Can I move to ethics? Yes. Can I just, there's some people that never got a chance. Connie, I just want to hear what Connie has to say. I don't want to ignore Connie.
Yes, thank you very much. I wanted to find out about the attorney with the right of appearance in the High Court.
Okay.
If that is still, yes.
It's you have to have practiced as an attorney post admission for 3 years. So not including your years that you've done articles. Post admission. So after you have been admitted, you must have practiced for 3 years. Then you apply to the registrar for admission as for right of appearance in the High Court.
Okay, thank you.
And it's in terms of the admission of advocates for right of appearance in the High Court Act. It's a 1995 Act. Okay, there's a lot of hands still. Is it some people want me to move on? Murema, what is your question?
Thank you, Advocate. 2 questions. Why the bar does not want to allow members of the bar to share the office or the chamber with the non-bar members? Second question, why the advocates within the bar do not allow the non-bar members to appear together with them in the courts as a junior and a senior counsel? Thank you.
Yes. Okay. So you're asking me ethical questions for those people who want to move to ethics that you will find in ethics that you're not allowed as a member of the bar traditionally. That was it, to practice alongside or to appear in matters. That is just that is just the rules by which they operate, and their members ascribe to that rules. So that is that. I can't say why. I don't know why, but traditionally that is they wanted people to all be trained by them, and that is what their rules were. I can say this, that there is a group of advocates in Johannesburg that has both members of the bar and non-members of the bar, and they are operating as such with the bar's knowledge. It's just that there must be clarity as to who's members of the bar and who's not. So the rules are bent and broken, and they're still practicing. So there's one specific group that I do know of that has members of both. I used to be a member of that group that has members of both the non-members of the bar and members of the bar, and they do practice alongside each other. So maybe it's still written that it's not allowed, but in practice it is allowed in inverted commas. Yeah. Right. Now can I move on? I think so. Ethics, I'm not going to spend a lot of time on ethics, and ethics is the wrong word there. Let me just make that disclaimer, I should have said code of conduct. I should have changed it. I thought I did. I did not change it. So because somebody took me to task in one of the classes and said, why do I say it's ethics? Ethics deals with morality and what's wrong and what's right. And this is not what I'm telling you. What I want to tell you is just how to behave in court. When you get into court, you bow in the direction of the bench if the court is in session. That kind of thing I'm telling you, just a few of that. So when you enter court and the judge or even the magistrate's court for that matter is there, then you bow in the direction of the bench. And when you leave, you do the same. Now, when you are in court and the judge enters the court, you get up, right? When the judge enters the court, you stand. And then you will see that the judge bows in your direction. He bows first in your direction and you bow back to him. And then he will sit. And only once the judge has seated himself, then you can sit. Okay. If the judge addresses you directly in court, then you stand up. You never sit down while the judge is talking to you. Obviously, unless you are in a wheelchair or you can't stand for some or other reason. But you stand up and you listen to the judge. And when you talk to the judge, you also stand. You don't sit down and speak to the judge. One of the things which I found a bit strange because of habits and the conventions during COVID, when we did most of the matters virtually, you were seated when you were speaking to a judge, and it was very strange to me that I don't stand when the judge addressed me. But that was just how it goes. So you would stand when the judge addressed you in open court, and yeah, and then you call the court. In high court, we call the judge my lady if it's a woman, and my lord if it's a man. Yeah, and you would ask the court if you want to do something. So if you want to quickly take an instruction from your attorney, you won't just speak to your attorney. You would say, may the court give me permission or grant permission that I just quickly take a word from my instructing attorney. Or you'd say something like that. People use flowery words, I always say, when they speak in court. Or might I beg the court's leave to hand up this document? And then obviously the usher will come towards you, give it to the usher, would give it to the judge, the secretary would give it to the judge. Right. Now, in each and every matter, even in the match court, if you are going to appear before a judge for the first time before that judge, not for the first time in the matter, for the first time ever in your life before a judge, then you have to go and introduce yourself to that judge. Okay. So what you do is basically you would go to court, and before 10 o'clock, say the court starts at 10, before 10 o'clock, everybody must be in court, because the judge is not going to come to court and then wait on litigators to come to court and to be ready for him. Everything must be ready when the judge enters the court. One thing that I forgot to tell you is that the High Court has what we call a continuous role. Unlike the magistrate's court, where a matter is set down for 2 days or so, and then when it's at the end of that time, the matter is not finished, concluded yet, then the parties agree to a following date when everybody is available. You will see the magistrate takes out his diary, everybody takes out their diaries, their phones, and they see when they are available, and they then postpone it to that date. Now, in the High Court, a matter is set down from beginning to end to run continuously. So they have what we call a continuous role. So if a matter is going to run for 2 weeks, then for 2 weeks, every day of that 2 weeks, people must be in court for that 2 weeks. And that is one of the reasons also why, despite attorneys having in court and having a right of appearance in the High Court, they still brief advocates, because the nature of the two practices are so different. An attorney wouldn't easily give up 2 or a month even just to go to the High Court every day and miss all of those incoming traffic, all those work that comes in every day by being away from his office. Whereas the nature of an advocate's work is to do a matter at a time. Advocates can't take more than one matter on a day. They can only they can't double book. They can only do one matter, and they can't be in 2 courts at the same time. Whereas attorney can take 2, 3 matters, and they just make arrangements with the prosecutors or with whoever. Look, I'm 11 o'clock in this court, or I'll be there this afternoon, or whatever. They have that luxury. but advocates has to be there every day. So before you appear before that judge, you have to, for the first time, you have to go and introduce yourself to the judge. So this usher will come in and he will say, are there any people that want to introduce themselves? And if you never appeared before that judge, you have to go. Now, if the matter is opposed, then you must take your opponent with you. You can't go alone. If it's an unopposed matter in the unopposed motion court, then you can go to the judge on your own, and all you do is that you just say, I'm so and so, and I will be appearing in front of you today or before you today. And then the judge will say hello. Sometimes the judge will know people, you know, your principal or something, and make me chat, or sometimes they will just take your hand and say, okay, see you in court. I don't even know if they take hands anymore with COVID, but introductions are done like that. Sometimes you won't be able to make it. The judge would already be on his way to court and wouldn't wait for introductions, and then you come to court 5 to 10, and court starts at 10, and they say no, the people has already been to introduce themselves, and then you didn't get a chance. Now, if that happens to you, when they call your matter, now usually the registrar, the judge's secretary, we refer to that secretary as a registrar, but that is not officially a registrar. It's just people in the High Court say the judge's registrar. It's the judge's secretary. Now, the judge's secretary would usually call the matter, say A versus B, matter number 2. And then after it is called, the first party who appears for the plaintiff or applicant will get up. So say it's a motion, the party will get up and say, may it please the court, my lord, I appear on behalf of the applicant in this matter, and then sit down. And then the other party will get up and say, may it please the court, my lord, I appear on behalf of the respondent. Now, this is from the place where the judge already met both of you, right? Even if he met you that day or before, but he knows you because you have introduced yourself to him. If you didn't get a chance to introduce yourself and it's your first time appearing, don't start rumbling, I appear on behalf. Just first apologize. Tell the court the reason why you didn't come and introduce yourself. Judges, they take this very seriously, and they take it as disrespectful if you don't do it. So just say, my lord, my apologies. I am so and so. I appear before you today, and I could not introduce myself today for whatever reason. And you tell the court, and then the court will usually say, okay, go ahead, and then you tell him you appear. Because if you're just going to say I appear, then the judge will say, who's this? I don't know who's this. Why didn't you introduce? And they will take issue with it. That's just the tip. Yeah, what else can I say? I will mention more things on ethics as we go along, and I remember. I'm not going to spend a lot of time there unless I have specific questions on, yeah, there's hands up on this. I don't know if this is old hands because these hands were up earlier on. Godfrey, is this an old hand?
Yes, an old hand.
Tulasiwe? And Connie, your hand was up earlier. No questions from how you behave in court, what you have seen?
Oh, sorry.
Anything? Yes.
Oh, my apologies. My hand is a legacy hand.
It's tired now from being up.
Yeah, we are getting complaints that we must move on.
No, ask your questions. We can only learn from other people's questions, because sometimes you ask something that, and then I explain it in a different way, or didn't even address it. So if you have a question on any behavior in court that you've noticed and that you maybe wondered about, ask me now. If I know the answer, I can oblige.
Advocate, I just want to check this. Well, when the matter is not opposed, well, I heard you saying that if a matter is opposed, then you must go with your opponent.
With your opponent, yes.
Yes. Now,
even if your opponent knows the judge. Mm.
Yeah. Oh, okay. Thanks for that information.
Is that your question?
I just want to check. Yes. No. I just want to check that what happens in an event that the matter is not opposed, and
then you can go alone.
Yes, but I want to check what is the role of the judge's clerk, because I read somewhere that
You cannot just go to the judge without
You
having
go to him
gone
first,
through
yeah.
that is clear.
Through the yeah. When you get there, that person will be there, and they will go and tell the judge that the advocates are here to come and introduce themselves. Yes.
Oh, okay.
That is
No,
their
thanks.
role. And they would you come in, or they would stand by the door, but they could hear the conversation. This is also that justice can be seen to be done. The fact that if it's an opposed matter and you go alone to a judge, it doesn't look right. Even if nothing is going to happen, you're not going to discuss the matter in the absence of your opponent with the judge. Even if it's not going to happen, it must be seen not to have been done. That is why even if your opponent knows the judge long and appears it before him every day, he must still go with you because it's an opposed matter. And if it's an unopposed matter, the secretary, the judge's registrar will stand there and usually will hear everything that is being said. It's just a measure so that the judges can be seen to be unbiased and to be independent and impartial. It's just to ensure that. Even though nothing is going to happen, you're never going to do anything like that. They just do that, yeah. Any other question? None. Right. Godfrey, you're gonna remain, your hand is going to remain up. Okay, I'm just going to start off with this. I have more or less time to start with the pre-litigation states. Now, what we did basically up until now, and still we're going to do part of it tomorrow also, is just the background preparation, because then we're going to go into the procedure and how to get it. But in order for us to understand that, we had to do what we did tonight. So before you're going to litigate, we get to the stage where we call it the pre-litigation stage, or I call it the pre-litigation stage. That is now before you decide you're going to litigate. Now, this is an important part in the procedure, right? When you decide you're going to litigate, first of all, your client will come to you, and you will have to consult with your client. And the client would usually come to you after they have telephoned your company that you work for and ask to see a lawyer and say what it's about. And the most important aspect, and usually this will be at the first consultation, is the aspect of finances. What is your rate? And then the client will have to decide whether he can afford you, and you must decide whether you're wasting your time and you won't be paid. So usually, to avoid that, attorneys, as far as I know, ask for a first consultation fee. Whatever their first consultation fee is, say it's 2,000 and they say you must bring 2,000 and, because now you're first going to then at the stage gauge if your client does have a case. Because sometimes clients think they have a case, and then you as a lawyer, when you put on your lawyer hat and you look at what they are telling you, see, but you don't really have a case. And you can't do that for free. You've invested time and you've listened, you've applied your knowledge, so you get paid that. But at the pre-litigation stage, that is the taking of the instructions. So if you read through your notes, you would see that they say that you must put the client at ease first before you get into the, and then you have to let your client speak and tell you the story, why they are there. And at this stage, at the first stage, you must let your client speak in his own words, so that you get it in his own words. You obviously, as a lawyer or as a person with legal qualifications, know the, what the gaps are in the matter. But let them first tell the story in their own words, write down the instructions, and then after they finish, then you ask questions. Okay, then you would say, now what about this? And did that happen? So that you can see, okay, do they have a case? And then you fill the gaps in. And then whether they in fact have a case. That is basically how you would do a consultation. So first let them tell the story, and if there's certain documents and stuff that they have to bring, you would tell them, look here, you need to bring me this, you need to bring me that. You say this, but who can give in, who knows about that? Because that would be a potential witness who can say something that your client maybe don't know. So you would ask the relevant questions after they have told the story in their own words. Okay, they might tell it doesn't make sense, but you're going to try to make sense of it afterwards. Right. You have a responsibility towards your client to tell them whether whether there's a chance of success. I would usually tell clients, look, I don't think you have a case, but I suggest that you go and see another person and ask them if you think you have a case, if they think you have a case. I don't want to say you don't have a case and then later on they will say, but you advised me incorrectly. Your responsibility to the client is also tell them what it will cost them. You will enter into a fee agreement in most cases, where he will sign and say that he will pay you, and then you will say what you need, what monies you need up front before you can do X, Y, and Z, and then at each step you will inform him, but this will all be included in that fee agreement. What is also advisable is that you confirm the instructions in writing so that there's no misunderstandings later. The client can't come back later and say, but this is not what I told you. Because if you confirm the instructions in writing, also confirm any outstanding documents that need to be brought. And also if there's a chance that the matter might prescribe, remind them of that and also tell them what monies you need in order for you to start. And if you don't start, this is the consequence. If you have all of that in writing, later on you are protected if the client should blame you if things don't go their way, if things happen. But just remember that, confirm the instructions, enter into a fee agreement, protect yourself. Yeah, and then if they come to your office, you open a file. And in the file, you can have sub-files, which have all those headings with all of those things in. Just remember, as a candidate attorney, if you're working on a file, please make notes of everything that you have done. Because remember, you have to bill them for each and everything that you've done in the matter. And if you bill them for what you have done in the matter, people that come later on and work on that same file must know that something has already been done, and don't duplicate the work and have the client pay double for something that has already been done. So make your notes legible and understandable for whoever's going to follow you. Remember, as a candidate attorney, you're going to be there maximum 2 years, sometimes 1 year. And then the matter is going to be somebody else's baby, and they must know what was already done so that they don't repeat. Remember, we always act in the interest of our client, and part of that is not letting them pay unnecessary. Okay, so you would clearly state everything you've done in the files. Yeah. Do I have any questions on that? Because that is where I'm going to end tonight. I'm going to do letters of demand tomorrow. Any questions on consultations?
Advocate.
Advocate, I have one. I have a question.
If you say,
okay.
Okay.
I just want to ask, as a candidate attorney, when you consult with client, is it always that your principal must be present?
Well, that depends on the principal, really. I mean, I know of people that are left on their own devices. It depends on the size of the firm. But if you're going to consult before you do any work, and that you obviously have to find out if you're not sure from your principal, or ask for his guidance. But I know of firms where principals are not always present, and there's nothing wrong with that. Yeah.
Okay.
Because remember, the principal also has his own work.
Okay.
So
thank you.
Yeah. Okay. Yes, Sipo.
thank you, Advocate.
Yeah.
If you say that the legal practitioner must let his or her client to tell her story, and when internalizing the story of the client, and I find that the story doesn't make there's no logic, or it doesn't make any sense. Is it not my duty as a legal practitioner to assist her to build up a better story?
To make up facts? No, you can't make up facts for your client. You use the facts that the client give you. Oh,
not to make up facts, but make sure that the story is sensible and truthful.
that's what comes in by the second part when you ask the questions, when you put on your, that's why I say you put on your lawyer's hat and then you ask the relevant questions to see, is there really a case here, to try and make sense of it. But first you get it in their own words, and then you fill the gaps later to make sense of it all. But it's on their facts. You don't add facts to make it better. Yeah.
Okay, thank you.
Okay. Anything else? Okay, then I'm going to leave you here for tonight and I'll see you tomorrow at 5.
Thank you.
Thank you.
Thank you, Advocate. Wish you all the best for tomorrow.
Thank you.
Thank you,
Thank you very much.
Advocate.
Thank you.
Good night,
Have a nice
everyone.
day.
Session.